Final case on today's case call is People versus Haynie. It's a full grant with 20 minutes of argument per side.
Good afternoon, Your Honors. My name is Cecilia Kirandango. I represent Mr. Brad Haynie on this case. This leave was originally granted on two issues. The first issue was whether the offense of assault and battery was a necessarily included offense of assault with intent to murder. The prosecutor is conceding that issue, so I wanted to ask the panel if I still needed to argue that particular point, because the people were kind enough to concede that.
I appreciate the question. Does anyone have questions about the conceded issue? No, I don't believe so.
Then I will pass to the second issue, which was whether Mr. Haynie's case, or a particular set of facts, entitled him basically to the lesser included instruction with whether a rational trier of fact could have found him guilty of the assault and battery. This case was interesting because Mr. Haynie was originally charged with the assault with intent to murder. The trial court did grant him an instruction of assault with intent to do great bodily harm less than murder, and the jury was also instructed on insanity. In Mr. Haynie's case, there were three experts presented, along with some other witnesses. All three experts opined that Mr. Haynie was legally insane at the time that the offense was committed. There were additional two witnesses that were presented by the defense attorney who supported the argument that he was insane at the time that the offense was committed. The Court of Appeals focused a lot in this case on the extent of the injuries that were suffered by Mr. Haynie's mother. The dissent pointed out that the extent of an injury is not something that needs to be considered in order to find someone guilty of assault and battery. Instead, the dissent indicated that the intent was what was important, and that in Mr. Haynie's particular case, there was evidence supporting that he didn't intend because he was legally insane. The people in their reply brief to this court are arguing that Mr. Haynie's diminished capacity, citing one case in particular, which I believe was the Carpenter case, that didn't support the argument that Mr. Haynie should benefit from the assault and battery. However, in that particular case, I believe that Mr. Carpenter was found to be legally sane, which was way different from this case. This case, basically every witness who testified in this case supported the idea that Mr. Haynie did not, in fact, have the required intent necessary to, I guess, the specific intent required to find him guilty of the assault with intent to murder. And the jury, although they didn't come back finding him legally insane, did find him guilty of the only lesser included offense that they were presented with. So I think that this is a case where absolutely the evidence, even though the extent of Mr. Haynie's mother's injuries were significant, it was a case where a rational jury could have found him guilty of an assault and battery. Keeping in mind too that the jurors they don't know what the maximum possible penalty is. They wouldn't have known that assault and battery is a misdemeanor as opposed to either a 10-year or a life felony. They would just have been left with a choice between what kind of intent Mr. Haynie had formed. And I think in this particular case it was supported by the evidence, and I think that they could possibly have found him guilty of the even lesser included offense.
Would it be possible that he lacked the mens rea for the greater offense, but nonetheless still possessed that same mens rea for assault?
Absolutely. I mean, the jury didn't find him. The jury didn't find him not guilty by reason of insanity. So I'm sure the jury, and originally I had made also an argument about the great weight of the evidence because I thought, there was ample evidence that he didn't possess enough mens rea to form the intent on anything, really. But the jury came back otherwise. But I think if they had been presented maybe with an even lesser offense, they could have decided on that. I think the evidence supported it.
Not to go back on our agreement not to ask you about the concession, but
But
maybe you should spend a few minutes on that
Yes.
issue and explain why assault and battery, not assault, but assault and battery is a lesser included offense in this case.
So there is case law that says it is. There's a lot of published case law that says it is. I think the only case that says it wasn't was the Ora case, which the Court of Appeals relied on. That was, in my opinion, bad case law, and I think the courts have ruled otherwise since then. The assault and battery, and I went through it in my brief, assault and battery, you must find some form of assault before you can then find the greater offense of intent to murder or intent to do great bodily harm. You must necessarily first find that an assault was committed. I understand, and the Court of Appeals, they talk about, well, they could also have found battery. Okay, in this case, it was clearly a battery. It was not just an assault, but battery is basically, I guess, the consumption of the assault. I think my argument is supported by the definition that I provided from the Black's Law Dictionary too, which basically says that assault with intent to murder is an assault plus some more intent.
It's an assault, but not an assault, not an assault and battery, right?
Correct.
Doesn't have the battery aspect.
Correct, but if you read the assault and battery statute, it says you can either find assault or assault and battery or battery. So you can find all of them. So I don't think you don't have to find a battery to find someone guilty of the charge of assault and battery. And I think if the plain reading of the statute, I think it makes it pretty clear that assault with intent to murder is really nothing but an assault plus the added intent to commit a murder.
And the requested instruction here was as for assault or for assault and battery?
Well, the attorney requested 750.81, which, is the assault and battery statute. So, and I, in the jury instructions that was submitted, I believe it was just the statute that was requested. He also requested aggravated assault, which was denied, which I would concede is not a necessarily included offense of assault with intent to murder. Could a jury possibly have found, or maybe found Mr. Haynie guilty of aggravated assault? Yes, but it was not, it does nothing for my argument because it was not a necessarily included offense.
Okay.
And I don't know if there are any other questions, but I think it's a pretty straightforward argument. It's a very factual argument, and I think it's really about going through the record. Yes?
Can I ask you just one quick factual
Yes.
question, because I think it might be relevant to the necessarily lesser included issue. Did the document in this case charging defendant with assault with intent to murder also allege a battery?
The statute on assault with intent to murder does not include the word
I
battery.
understand that, but did it also,
I don't believe this, not the information. I think the information was the statutory language, if I recall right. So it would not have included the word battery.
okay, thank you.
With that, I would ask that you reverse the Court of Appeals and send the case back to the Macomb County Circuit Court for a new trial.
Thank you.
Thank you.
Good afternoon, Your Honors. Emil Sama on behalf of the appellee, State of Michigan. As you know, I have conceded issue 1 regarding whether A and B is lesser included. I still stand by that, I think, at this point. However, I do disagree with issue 2, that a rational view of the evidence did not support the giving of the instruction. And there are 2 things to respond. 1 is the defense argument, and 2 is the dissent's argument. And the dissent, I don't think, and I disagree with Sister Counsel, that they weren't really looking at his mental state as the basis of why they believed A and B should have been given. Judge Gleicher's reasoning had to do with the fact that people v. Detima would have allowed for it. However, I believe Detima to be an opposite. That had to do with the felony manslaughter rule and the one-punch rule that allowed for that to be allowed even in the wake of people v. Aaron. But what she considered specifically was that the mother, Patricia Haynie, testified that this was not my son, right? However, that one piece of testimony, taken out of context, is really not helpful to the dissent in this regard, because if you look at what she was arguing was, my son would never hurt me. Whoever was doing this to me, this couldn't have been my son. Whoever was beating me, shaking me, hitting me with the cane or the horseshoe stick that had blood on it, this was not my son. Unfortunately, it was. And the difference that she found, and Judge Gleicher said, was the difference between the lesser included and the greater really had to do with intent, not the severity of the injury. I agree, intent is the question. But the intent we look at can be proven by all the facts and circumstances of the situation, right? Not just the severity of the injury. That's just one factor to be considered. But you also consider what was used. Was a weapon used? I think it was in a couple of situations you look at is was a dangerous weapon used? Was there injury, even though injury may not be required? What was said, what was used, what was done, the circumstances before and after. Especially in here, he denied assaulting his mother, blamed it on Fred Yaks, and admitted to drinking. The issue here with that was this the kind of case, like in Tatima, where it was a one punch, a one push that could have caused serious injury? No, this was a sustained attack. The reasoning was he wanted to get Lucifer out of her body. So at the very least, he wanted to kill Lucifer or get him away from her. What happened to her mother was the result of, his mother was the result of this. So it's not the fact that the dissent argued was this one snapshot. I think Mendoza specifically argued against that snapshot language, because Mendoza specifically said the defendant's statement alone was insufficient to support involuntary manslaughter instruction given the evidence. That's what they used to ask for that in Mendoza. Here it was, what Judge Gleicher requests in the dissent is this one statement from Patricia Haynie should be enough to get the A and B. That would not factor in with all the other evidence. So then the real question comes down to, as Sister Counsel argued, his mental status. He tried for insanity, which would have been a complete bar to responsibility. He would have been found not guilty by reason of insanity, which means he was not culpable of any intent, which I believe goes to Justice Marksman's question about the mens rea that he asked Sister Counsel. His mental state would have precluded any form of mens rea, whether it was A and B, GBH, AWIM, if the jury had found him not guilty by reason of insanity. They found him guilty but mentally ill. So to say that he should have gotten the A and B because of his mental state basically revives diminished capacity. It says because of his mental state, he couldn't form the mens rea, so we should give him a lesser included because of his mental state. That's what Carpenter specifically disallows. And to allow it to say, well, no, because of this specific person with his mental state, we should allow him to have the lesser included, voluntary intoxication, because his admissions of drinking and the whiskey bottles that were found in the home, diminished capacity returns. And that is not proper given what the facts of this case were and what Carpenter says. So at this point, I don't believe a rational view of the evidence would have supported it.
Could I follow in my colleague Justice Giuliano's footsteps and gingerly inquire about the verboten issue in this case?
Yes.
You've obviously made a concession here.
Yes.
And as I look through the law, I see a number of cases, Turner, Andre, Keurig, that all seem to say fairly straightforwardly, and have said so straightforwardly for a very, very long time, that a defendant in a case like this, where assault with intent to murder is charged, is not entitled to an assault and battery instruction if the charging information did not also allege a battery, which was the focus of my question to opposing counsel. Should we treat your concession with just a wee bit of salt or skepticism?
I'm not trying to be rude. You don't have to accept my concession at all. You are the 7 founders of this court. You can agree to a stipulation or disagree. In fact, the Court of Appeals has recently said even when the parties agree to an area of law, they don't have to accept it because it's a question of law and the courts decide the question.
What was
of law.
most significant in causing that concession, bringing that to being?
I'm sorry?
What was most significant in influencing your decision to concede on that point?
That in the concession is that if it was an assault, if we have an instruction for assault, then at the very least, assault is subsumed with an assault with intent to commit great bodily harm. So you can't really have an assault without you can't have assault with intent to commit murder or assault with intent to commit great bodily harm without having the assault first. Now, I know he may have asked for assault and battery. I don't think there was really any question in this matter that she was battered. She was beaten. She was attacked. I'm sorry, I'm not familiar with the cases.
Of these cases was upon the charging document. Do you have any sense that I'm misconstruing or misunderstanding those decisions?
No, I do not. I'm sorry,
No, that's fine. Thank you.
yes, okay. But I mean, at this, like I said before, whether or not you accept or there's a limited point where maybe just assault would have been a lesser included instead of assault and battery, because the statute does have the or language in the statute itself, or where the charging documents require it. I believe in this situation, though, even assuming that it is lesser included, a rational view did not support it in this matter. And if there's no further questions, I would
see
ask
no
that
further
you
questions.
affirm,
Thank you, counsel.
thank you, at least partially the Court of Appeals.
Thank you. You reserved some time if you need it, but I don't know if you have any.
No, I'll rest.
Thank you very much. The case will be submitted, and that ends today's case call.